paid? Who is asserting in this case that claimant's gratuity has been paid?
Yes, my lord. The defendant, of course,
who is
and
making
the
the assertion that
too,
claimant has been paid?
That his gratuity
Listen.
has not been paid.
Wait. So who asserted first that, look, I have paid Mr. A all his entitlements? Who said so first?
The claimant, the claimant alleges in his pleadings that he was not paid his gratuity. Then the defendant in his reply said that he has paid. And then
so
the defendant
if you are now saying you are paid, listen, if you are now saying you are paid, listen, listen, if you are saying you are paid, then you should have something to show the court that indeed you are paid. What did you put forward in the court? I'm listening.
Yes, the defendant tendered a document which was submitted as an exhibit to demonstrate that
they are paid.
Yes.
Exhibit what?
The Lord, that is exhibit P7. P7. Exhibit P7.
Just a minute.
As the court pleases. Yes, my lord. That is what the defendant tendered to demonstrate that it paid the claimant all his gratuities or other benefits. And then the claimant himself undertook by paragraph 5 of
which
his
is
reply
the 100% of
yes, yes, my lord.
Has been credited to your account.
Yes, my lord. Yes, my lord. Then the defendant himself.
And you said the claimant in paragraph what?
Yeah, the claimant himself in paragraph 5 of his reply. To the defendant's statement of defense stated clearly that he would produce his own statement of account.
He said
which
it has not been
with the
paid.
Defendant.
He said it has not been paid.
Right. And then he promised to produce the statement of account, my lord,
so
to show that he was not paid.
Ame Esquire.
Yes, my lord.
Paragraph 5 applied to the defense.
See.
The defendant had asserted that they had paid. They produced exhibit P7 to show that they paid 400,516 naira 84 kobo. And the claimant replied that he has not been paid and that he would produce the statement to show that he has not been paid. Did he produce the statement?
My lord, sir.
The statement of his account.
My lord, sir, is solely on the defendant that alleges to prove.
Wait, listen. Listen, they have proved by showing the letter. And they stated in that letter that they are paid into his account. Exhibit P7, that they are paid that sum, the sum of 400,516 naira 84 kobo into his account that is domiciled with the bank. And the claimant, in response to that, said, no, you didn't pay. That I shall rely on the statement of account, on my statement of account. So where is your statement of account to show that they have not paid you? That's the question now. So if you have admitted that you will show a statement of account, no, they didn't pay me. So I have a statement to show that they did not pay me. So you still have that onus to produce that statement of account, produce a letter stating that they have credited the account of your client. Mr. Ame?
Yes,
the
my
court
lord.
will look at it. Do you now have the statement of account of the claimant?
My Lord,
Mr. Ame.
yes, my Lord. I don't have it right now, sir. Because we were believing that is the sole responsibilities of the defendant to show to the court that they have paid.
My Lord,
sir. Yes, my Lord, sir. Can I just apply for 30 minutes stand down to bring the statement of account, sir? Or alternatively, to serve on the adverse party and file in the court registry, sir.
Can you, do you have to do what? In adoption? In adoption? No, you can't do that.
As a copy.
Come by it as a cherry. You ought to have produced that before now. Which means you are very, very tardy in handling your case. So I won't give you that opportunity to do that.
As a copy.
So I will give you a date for.
As a copy.
Please.
As a copy. My Lord, finally, my Lord. Finally, my Lord. My Lord.
Mm-hmm.
Yes, my Lord. Mm-hmm. My Lord, it is trite law. It is trite law that the burden, the primary or fundamental burden of proof lies on a party who would fail if no evidence at all were given on either side. On either side. The fundamental burden of proof lies on the party, on the litigant, who would fail if no evidence were produced or were given by either side. And my Lord, we have cited that authority and also referred to section 132, vide paragraph 1.9 of our reply. Thank you, my Lord.
Very well.
I'm grateful, my Lord.
Very well.
Thank you, my Lord.
Case adjourned to 7/7/2022 for judgment.
Ask up, please.
Call the next case.
File N 2022 between Ansonia Ojua Omega and 1. Kogi State Polytechnic, 2. Kogi State Government. Applicant is in court, my lord. Respondent.
Profound respect to your lordship. Applicant is in court.
Mm-hmm.
W.A. Aliwo is my name, my lord.
Mm-hmm. Appearance.
I appear for the applicant. W.A. Aliwo is my name, my lord.
Very well. Mm-hmm.
I'm not saying my lord is in. My lord, we have a motion ex parte before your lordship.
I'm listening to you.
My lord, it is brought pursuant to.
Well.
Hello, my lord. Sorry.
I'm listening to you what you are asking for to see whether or not it's because the judgment says they should pay 5-point-something million, and you are asking for 8.4 million. How did you arrive at that amount?
My lord, if you look at the judgment and the orders that were made by your lordship, sir, it talks about the order is to the effect that the monthly salaries.
Yes.
The monthly salaries calculated and in accordance with the claim should also be paid.
From July
2017
to July 2020.
I'm not seeing my word.
Yes.
My Lord, it is an accordance. The calculation is based on the summation of the total monthly entitlement of the applicant up to the time of the application that brought the judgment.
Is it in the judgment? Is it in the judgment?
Yes, my Lord.
You can't claim what is not in the judgment, except if the judgment debtors had calculated that amount and had communicated that to the claimant.
My Lord.
Because what I have here as the sum to be paid to the claimant in the judgment is 5,601,780 naira.
Yes, my Lord.
So if you have added extra, that should have come.
My Lord, if you look at your judge,
if I look at what?
The judgment of the court, it is that the applicant is entitled to it. Is still a staff of the judgment debtor.
That's paragraph 32. Then paragraph 33 specifically says that you should be paid salaries from July 2017 to July 2020 in the sum of 5,601,780. Nene Council, can you hear me? Are you there? Are you there, Mr. Liwo?
Yeah, my Lord.
Yes. Have you seen paragraph 33 of the judgment?
Yes, my Lord, I have seen it.
So how much did the court say should be paid to the claimant?
My Lord, by that paragraph, by the preceding paragraphs, my Lord had ordered that the applicant is entitled to the monthly salaries. And what we calculated, admittedly, to be the monthly salary is what we added that we are asking from my Lord.
Then Council.
Yes, my Lord.
Then Council, which one did you add? That's what I'm saying. You cannot so moto add, except if the defendant, the judgment debtors, have written to say, oh, this is your entitlement up to date.
My Lord, that had been determined by your Lordship already.
Yes, I determined and I said he should be paid 5.6 million.
Okay, my Lord, we will,
So you have to come back.
Yes, my Lord. So we'll come back with an amendment.
Court registrar, give me a date.
My Lord, 18th May.
18th May.
May, yes, my Lord.
Is it convenient?
I'm checking in, my Lord. It's convenient, my Lord. It's convenient, my Lord.
Yes, adjourned to 18/5/2022 for hearing of application. Call the next case.
Case number 3. LKJ 25/2020 between Yunusa Onu Danjuma and 175 others. There's 1, Reform Nigeria Limited. 2, Mr. Ata Achimogo. 3, Ajakuta Steel Company Limited. 4, Ministry of Mines and Steel Development. 5, Attorney General of the Federation. 6, Federal Government of Nigeria. My Lord, claimant number 49, 97,
So they are created after
110, 113, 120, 127, 133, 139, 163, and 169 are in court, my lord. Others absent. Defendants are also absent.
Appearance.
Please, my lord. My name is Austin. I'll disappear for the applicant.
Any other appearance?
Yes.
Any other appearance?
Yes, my lord.
Any appearance for the respondents?
Yes,
Go
my lord.
ahead.
My lord, we profound respect. My name is John.
I can't see you. I can't see John. I can't see you.
My lord, we profound respect. My name is John Madaki. Madaki is spelled M-A-D-A-K-I.
I've seen it. You are for who?
My lord, my appearance is for the defendant number 3 and 4. That's the Ajaokuta Steel Company and the Ministry of Mines and Steel. May you please, my lord.
Very well. Any other appearance? Any other appearance? No more appearance? No appearance for the first. Okay.
Not in the open court, my lord.
Go ahead, Mr. Boni, have you filed the general form of complaint?
Very well, my lord, sir. Heralded by
Mr. Boni.
Yes, my lord. We filed it and we have a motion heralding it, my lord. We are ready for the application.
When did you file the process and the motion?
On the 14th day of April, my lord. And parties have been served.
Very well.
What?
Subject to my lord's convenience, sir. We are ready for the motion, my lord, sir.
Mr. Madaki, have you been served?
Well, my lord, I have not been served. I have not received any process from him in compliance with the orders of the court as at the last emanating from the last ruling.
Mr. Boni? No, sir.
Did you hear what
we served their head office in Lokoja, sir.
Okay. So, Mr. Madaki, you have to contact your clients. They ought to have transmitted copies to you.
Well, Lord, I am most guided, but just a slight observation, Lord. Our head office is in Abuja.
Okay.
The head office of the third respondent is in Abuja. Lord is number 2, Luanda, in Wuse 2. So I'm not. I'm rather.
The head office of Ajaokuta Steel Company. Ajaokuta Steel Company is in Abuja.
No. The third respondent. That's the Ministry of Mines and Steel Development.
Okay.
I represent both of them.
You are representing Ajaokuta Ministry of Mines and Steel.
Very well, my lord. Very well.
Yes. So Ajaokuta will be served in Ajaokuta. Mr. Boni, where did you serve the fourth defendant? Where? Which address did you serve the fourth defendant?
We served the office in Lokoja, sir.
Ministry of Mines and Power in Lokoja.
Yes, they have an address. They have a. Is it branch?
Is that a proper service? Is that a proper service? Are you not aware
I'm sorry, sir. My client just informed me that they were served in Abuja. I'm sorry, sir. My client just informed me that they were served in Abuja and not Lokoja.
Are you not aware that Mr. Madaki is the one representing them?
Yes, sir.
Are you not aware? So why didn't you serve counsel? Well, Mr. Madaki, they said they have served.
My Lord,
the court bailiff should be set appropriately. There's a counsel representing parties in this court, in this case. So processes should be served on counsel, except where counsel has withdrawn his appearance.
As court places.
Before the court, processes should be served on counsel.
As the court places.
So take note of that.
Very well, my Lord. My Lord, in any event, we provided an address for service.
That's why I said they should be serving the address provided. Mr. Boni.
As the court places.
Mr. Boni, I don't know what sort of practice you conduct in as counsel in Lokoja. The court shouldn't be telling you all this. You know that. You shouldn't be waiting for your client to tell you all this. You as counsel, you've taken the brief. You have to conduct your case in the most respectable way as counsel and in accordance with the rules of court.
The court places.
So what do? They have an application to regularize what they have filed. And Mr. Madaki has no copies.
Well, ordinarily, if I had the copies, I would not be opposed to such an innocuous application. But it has made, Allah will leave it to the discretion of the court. But I believe service is fundamental that we ought to have been served before now, out of abundance of caution.
So let's take a date. What date?
Well, my Lord, may we be guided by the diary of the court.
Court registrar.
Yes, my Lord. 18th of May, my Lord.
18 May. It is a Wednesday. It's convenient for me, my Lord.
Claimants are to ensure service of the processes of the defendant's case adjourned to 18 May 2022.
As a court places.
As a court places. My Lord, we're most of them.
Further mention.
As a court places.
Hearing notices to be served on the other defendants, the first, second, and fifth defendants.
As a court places.
Call the next case.
Case number 4. NIC and LKJ 32-2020 between Aminu Tijani and Dangote Cement PLC. Parties are absent.
Appearances.
Respectfully, my lord, I'm B.M. Musa. My lord, I announce my appearance for the claimant. May it please, my lord, B.M. Musa. My lord, I announce my appearance for the claimant.
Any other appearance? Any other appearance?
No, my lord.
Very well. Any other appearance?
No, my lord.
Any other appearance? No appearance for the defendant?
No, my lord.
My lord, the matter is for
Mr. Musa, any report of settlement?
No, we regret to inform the court that parties are unable to settle.
Any report?
No, there was no reasonable offer from the defendant to the claimant.
Very well. So what do you want the court to do?
No, that will be asking for a date for hearing, Lord.
Court registrar, what date? What date?
19th of May, my lord.
No. I don't know
who is that person talking in courtroom? 19th of May 2022 for hearing.
I'm also sorry.
Notice to be served on the group to be filed.
We are grateful, Lord.
He said this in the other.
On the next case.
5, NICM LKJ 16/2020 between Sunday Awoyemi and 1 KCM Mining Limited 2 Alabi Samuel. Clement is absent, Lord.
Report.
Sorry, my lord, Clement is in court. The defendant.
Name one. What are you doing?
Second defendant.
Defendant.
Second defendant is in court. Not representing the defendant.
Appearances. I can't hear you. I can't see you. I can hear you clearly. I can't see AY Mohammed. Senior Counsel.
My Lord, am I listening now, my Lord?
Any other appearance?
May it please my Lord?
Any other appearance?
Yes, my Lord. UM Ibrahim. I appear with YM Jamiu, the defendant.
You what?
UM Ibrahim. I appear with YM Jamiu. For the defendant.
For the defendant.
Yes, my Lord.
The matter is for definite hearing. Mr. Mohammed, are you ready to case of the claimant?
My Lord. My Lord, for your Lordship.
Are you ready to open the claimant's case?
My Lord, sir.
I asked a question. Are you ready to open the claimant's case?
My Lord, you have emotion.
You have muted your set. Unmute your phone.
My Lord, we have a pending motion before your Lordship, sir. And it has to do with amendment of our process.
When was it filed?
It was filed on 22nd of February, 2022. Dated 18th February 2022, filed 22nd instant.
Mr. Ibrahim, are you in receipt of the application?
Very well, my Lord. Yes, my Lord.
Any objection?
We have no objection, my Lord.
Thank you.
You have no objection?
Yes, my Lord.
Move in terms of your application.
Thank you, my Lord, sir. Very briefly, the application is dated 18th February 2022 and filed in court 22nd of February 2022. Comprising two prayers, which we hereby adopt. The application, my Lord, is supported by an 11-paragraph affidavit and A, B, and C, respectively. We hereby adopt and rely on all the paragraphs of the said affidavit, as well as
have you filed a reply to the statement of defense?
Yes, my Lord, we did.
But you didn't file a further written statement.
My Lord,
You are filing a further one.
My Lord, I cannot hear you, sir.
Order is as prayed.
God bless it. Most grateful, my Lord. Are you my Lord, my Lord, sir. My Lord. Thank you, my Lord, sir. We need time to file a clean copy of the amended statement of facts. It's ready with us. We need just 24 hours to file it.
Clean copies are to be filed by the claimant within 24 hours.
Thank you, my Lord.
Copies served on the defendant. So take another date. Tomorrow's date is vacated. Take another date for definite hearing.
As copy. Tomorrow's date is vacated. So we should take another date for definite hearing.
Okay. As copy is my Lord.
So that's suggestion. Come on. This one is very important. Very.
What date?
Thank you, my Lord. I'm trying to 18th May.
What date?
How's your 18th?
18th May?
For me.
No, it's not for me. Exactly.
What date?
It's not 19. Oh, can still make that 18.
I'm already engaged.
We have high court 17, 18.
Let's try 18.
Exactly.
Sorry, my Lord. Subject to my Lord's convenience. 18th May.
18th. Do I have a sitting on 19th?
Yes, my Lord.
Oh, 18th and 19th.
18th.
My Lord, 19th is not.
18th is for the claimant, 19th is for the defense.
As the conflict.
Call the next case.
NICN LKJ 19-2020 between 1 Honorable Olorunsho Emmanuel Dayo, 2 Honorable Babalola Femi, and 1 Yagbawo West Local Government, 2 Ministry of Local Government and Chieftaincy Affairs. Claimants are in court, my Lord. Defendants asking.
Appearances. Any appearance? Any appearance?
Yes, Lord. With due difference, my name is Michael Odorumona. Announce my appearance for the people.
Any other appearance?
Yes, my Lord. With profound respect, Honorable Court, I'm O.W. Bible. O.W. Bible. But I'm appearing with me is P.R. O.R. Pepper. O.R. Appearance.
Pepper.
Yes, my Lord.
O.R. Pepper.
Yes, my Lord.
For
the defendant, Lord.
For all the defendants?
Yes, my lord.
Very well. The matter is for continuation, definite continuation of hearing.
Yes, my lord.
So, Olarumola, are you ready with your CW?
Yes, my lord, we are ready. We have a pending application before my lord.
When did you file it?
It was filed on the 9th day of February 2022. Ninth day of February 2022.
You want to amend?
Yes, my lord. An application for a slight amendment. The parties.
Mr. Obaido, are you in receipt of that application?
Yes, we're in receipt of it. And we.
Any objection?
No objection, my lord. No objection.
Move in terms.
Yes, Lord. Lord, the motion is dated the 9th day of February 2022. And filed. Lord, the motion was brought pursuant to order.
Move in terms.
Lord, we move in terms of the motion papers. We are most grateful.
Order is as prayed. Clean copies are to be filed within 24 hours and served on the defendant.
Hello. As it stands at the moment, the second defendant to be called has no statement on oath because all we have is a proposed statement, amended statement of claim which has just been amended.
You said who has no what?
The second defendant, who is to be the next witness, my lord.
Yes.
The statement has just been amended.
The second claimant or second defendant? The second claimant.
Yes, claimant. Mean the statement on it has just been amended. And my lord has ordered that claim to be served. I do not know if my learned senior can proceed to call the witness when there is no written deposition on oath for the court at the moment.
No, I'm not asking us to go. I said they should file clean copies of the processes amended.
At the court.
So if his statement is one of those that they are seeking to file, then they should file it. They should file it together.
As the court pleases.
They should file copies. So take a date. Tomorrow's date is vacated. What date?
Will not be guided by the
June.
June or May?
June.
No. We was in the same meeting.
What date?
June,
my lord. 14th of June, my lord.
14th of June.
Yes, my lord.
Milord, 14th of June is not too far for us.
Except if you come to Abuja.
Milord, I'm aware the court has been adjourned to 18th of May. And it's a free day for us.
The court is sitting on the 17th of May also. We do not know if it will be convenient. Court is
convenient. Not convenient. We have only 3 days in May. And they are still here.
Court registrar, is there any date in May?
No, my lord.
There's no date for them in May.
As the court pleases.
So, what date are you looking at?
Don't be guided.
What date? What registrar?
Yes, my lord.
What date again?
14th June.
14th and 15th?
14th.
14th and 15th.
Wait, are you taking 2 days? Yeah, no,
We'll be ready by then. 14th and 15th.
Is it convenient?
Yes, my lord, it's convenient to us.
14th and 15th.
Very well. 14th and 15th of June 2022 for definite continuation and conclusion of trial. Call the next case.
Case number 7. NICN LKG 06-2020 between Aya Sabatin and 8 others. Versus 1, Kogi State Government, 2, Ibaji Local Government Area, 3, Kogi State Basic Education Board, 4, Kogi State Attorney General and Commissioner for Justice. My lord, first and second claimants are in court. Others absent. Defendants are also absent.
Appearances.
Very pleased with that. My name is Off Obuni. On the subject for all units, sir.
Any other appearance?
May it please the court. J.U. Jonathan Omale, Chief Legal Officer, Ministry of Justice, Kogi. Appearing with me is F.B. Obayori, Principal Legal Officer. From Ministry of Justice, Kogi. My lord, our appearance is for all the defendants.
Very well. Matter is for defense. Are you ready?
No, my lord. We have a motion before the court.
When was it filed?
My lord, the motion is spring. It was filed on the 19th.
Was it filed?
19th of April, 2022. Hello, my lord.
Erin, you want to recall the claimant's witness?
Yes, my lord.
Mr. Oboni, are you in receipt of the application?
Yes, my lord.
Any objection?
We are not opposed, but on terms, my lord. We shall be asking for 50,000, sir.
What is the reason? What is the reason for that?
The witness they seek to recall, sir, has given evidence and been dismissed by my lord already, sir. And it's coming all the way from Ibaji is
from where?
Ibaji, coming from Obale in Ibaji. Obale is a neighboring community to Enu, Anambra State. He's in court presently. Just because we saw the application, I would want to delay the matter, sir.
You said he comes from Obale.
Obale, O-B-A-L-E, Lord. A community that shares border with shares boundary with Aguleri, Anambra State. To share boundary with Aguleri. They had to come in yesterday. Aguleri.
Omale Esquire.
Yes, my lord.
What do you have to say with regards to the issue of costs?
My lord, I'll be opposing his application for cost. In the interest of justice and fairness, and the fact that I'm just coming into this.
Why didn't you examine the claimant witness? What happened?
My lord, the grounds are all stated in our affidavit, in our motion paper. Yes, my lord. And this is my first time appearing in this matter.
Paragraph what?
Paragraphs 3 to 3A to J.
So why didn't counsel from the Ministry of Justice appear? Whose fault is that?
My lord, I don't really know, but he said he was not in receipt of the hearing notice that was sent to him. And that was what made him absent from court. So, and this is my first time of coming into this matter, my lord.
Who said what?
Hello, my lord.
I'm not saying who is coming in. The matter, the office of the Attorney General should ensure that there is an officer of that office in court handling the matter, irrespective of who the person is.
Yes, my lord. I said former counsel said he was not in receipt of the hearing notice that was sent with regard to this case.
He was not in receipt, but hearing notice was served on the office of the Attorney General. So it's not the fault of the claimant, neither is it the fault of the court.
My lord.
Move in terms of the application.
I move in terms of. Let's go to my lord.
Order as prayed. Recall cost of 10,000 are awarded in favor of CW.
As God
is to be paid on or before the next adjourned date.
As God
Invite CW.
Hello. My lord. We would have been ready to go on with our cross-examination this morning, but Human Council just said there was yet another motion for amendment of his originating summons.
Benin Council for the claimant. Did you file a motion for amendment?
My lord, we filed the motion for amendment of our claim, but we are not amending the evidence of the CW1. This is the CW1. We are only amending the evidence of the CW2. For this witness, we are not evidence.
Mr. Oboni.
one more document to another witness.
Mr. Boni, when did you file the process?
Yesterday, Milord.
You filed it yesterday, and you said you are seeking to amend what?
We are amending the statement on oath of another supposed second witness, not the second claimant who is giving evidence as TW1 or PW1. But the first claimant will give evidence, sir. It is witness on
just a minute. Mr. Boni.
Statement on
Mr. Boni.
Yes, Lord.
You filed a process titled amended complaint on 23rd of February. Is it in respect of an order granted by the court already?
You know, that one was amend the claim.
That's what I'm asking you. Has that been granted by the court?
That has been granted and clean copies have been filed already.
Okay, so which other one are you now talking about?
We want to amend our statement.
When was that filed?
It was filed yesterday.
Yesterday. Court register, is it here?
No, my lord, he's not there. He actually filed in the afternoon,
okay,
around 2 something. So we could not send it.
You should have scanned it. And that one you said is asking for what?
Leave
to do what?
To amend the claimant's statement of complaint. To amend the first claimant position of oath.
Wait, you had mentioned 2 things now. To amend.
The third was
how many prayers are you asking for?
3 prayers. 3 prayers, my lord.
The first one is to amend the statement of claim, which is the statement of fact in this court.
Yes, my lord.
And the second is what?
To amend the statement on oath of the first claimant.
You cannot amend the statement on oath. You can only file the fourth and better one. An affidavit. And the third prayer is what?
We will draw that prayer. Yes, sir. Then the third prayer is.
The third prayer is what?
Documents, sir.
Learned counsel. If you are seeking to amend the statement of facts, then it means you cannot go ahead with the case today.
Please.
So take a date.
Sir. Melissa, if our motion is so I will file clean copies before the next.
I don't have the motion. I don't have it. You have the court registrar said they have not sent it because you filed it yesterday afternoon. You are aware that this is coming up today and you chose to sit back, waited till afternoon yesterday before filing.
That's sorry, sir.
Very well. So you have to be at the front of that.
No, sir, if we can get within this week, just for the motion, sir.
What date court registrar?
For the motion, sir.
June, my lord.
registrar, what date?
14th of June, my lord.
14th June.
Yes, my lord.
No, sir. 14th June is far for the motion, sir.
Is there any date before that for the hearing of the motion?
A date in May will be better for us, my lord, sir. Just for the motion.
What registrar?
Yes, my lord.
Is there a date for the hearing of the motion before June?
19th May.
Okay, is it convenient?
It's convenient, my lord.
It's convenient, my lord.
Case adjourned to 19/5/2022 for hearing of motion.
As we are grateful, sir.
Most grateful.
Call the next case.
Case number 8, NICM LKJ 15/2018. Between Mr. Imohi Victor Eheledu and 1. Director, Auchi Polytechnic, Auchi. 2. The Registrar, Auchi Polytechnic, Auchi. 3. Auchi Polytechnic, Auchi. 4. The Governing Council, Auchi Polytechnic, Auchi. Parties are absent, my lord.
Appearances.
No appearance in the open court, my lord.
Did you serve hearing notices?
Yes, my lord.
Because they weren't in court at the last sitting, and I ordered for service of hearing notices on the parties. Do you have proof of service in the case file? Okay, 26th of April. Yemaki. Yes, I can see copies. Do you have telephone numbers of both counsels so you can call them?
Yes, my lord.
So call them after the court sitting to confirm whether or not they receive the hearing notices. And then give them the next date. What date?
14th June. 14th of June.
Is there any date in May?
Oh, my
so
lord.
We can mention it. Case adjourned to 14/6/2022 for definite hearing. Hearing notices to be served on the parties. Registrar of court is to put a call across to legal counsel for both parties.
As the court.
Call the next case if there is any.
NICN LKJ 10/2021 between Honorable Salami Lamidi and 11 others versus Ogorimagongo Local Government Council, Kogi State Minister of Local Government and Chief Council Affairs. Parties are absent, my lord.
Appearances.
Appearance.
You have to join because if in case, or do you have all the parties in the open court here?
No, my lord. The judgment debtor applicant is in Lokoja.
It's in Lokoja, very well. So you have to link up so that they can see you and hear what you have to tell the court. Who is that?
My Lord, with profound respect to this honorable court. O.W. Obaido, my Lord.
Wait, it seems there is you are counsel for who? And then you have to connect.
With utmost respect to this honorable court. Jerry, Dangana, Kura, for the judgment creditor, the 1st to 12th judgment creditor.
Any other appearance?
Profound respect to this honorable court. I'm O.W. Obaido. Appearing with me is O.R. Pepple. My Lord, our appearance is for the judgment debtor applicant. Almost good to my Lord.
I'm great, Namani. Your Lordship, I appear for the 4th Ganishi Access Bank PLC. May please report.
Lord, we have a motion.
When was it filed?
Filed on the 1st day of April, 2022, my Lord. My Lord, to which were in receipt of the judgment creditors counter affidavit. And we have also filed a further and better affidavit dated 13th April 2022, my Lord. Okay.
You filed it when?
My Lord, we filed the motion on notice on the 1st of April, 2022, my Lord.
No, you said you filed the better
Yes,
and
my Lord.
further.
Yes, my Lord.
You said you filed the better and further.
Yes, my
When?
Lord. 13th April, my Lord.
When?
13th April, 2022.
13th April.
Yes, my Lord. And my Lord, with the subject to the convenience of the court, we are ready, my Lord.
Very well.
Great.
Go ahead and move the application.
My Lord, can we go ahead to move the motion?
When was it filed?
My Lord, sorry, my Lord, we cannot
Just
hear the
a
other
minute.
person. My Lord, we can't hear him.
They are trying to help him connect.
All right. My Lord.
You filed a notice of preliminary objection. When? You are not connected. Mr. Obaido, can you hear him?
No, my Lord. No, my Lord, I can't hear him.
We filed a notice of preliminary objection.
Okay.
Dated 20 April 2022. And all parties have been served.
Did you respond to the motion filed by the judgment debtor?
Yes, my Lord.
When did you file that?
Motion. We filed a counter dated 11th April 2022. applicant and receipt of same.
You said you filed it
11th April 2022.
Mr. Baido, are you in receipt of the, okay, you said you are in receipt. Are you in receipt of the notice of preliminary objection?
Yes, my lord. We received the notice of preliminary objection on, my lord, just like on Wednesday, my lord. Wednesday last
week, Wednesday.
Yes, because we have also filed our response, but unfortunately, it's before the registry of this honorable court, my lord. We've not been able to complete the filing, my lord. However, my lord, my lord, going through the counter affidavit served on us by our learned friend, my lord, it seems our learned friend is laboring under some error, my lord. Because when I received the affidavit, the PO rather, my lord, I quickly ran down to the court and made clarifications on the position of things. And my lord, we were informed and assured that the processes before the court were proper, that it was deposed to before the registrar 2 of this honorable court, CK, my lord, CK Adesina, my lord, registrar 2.
Your own process, your own motion.
Yes, my lord.
That was filed on the 1st.
Yes, my lord. So, my lord, I do not know how the
Just a minute. You filed it 1st of April.
1st of April, my lord.
Did the commissioner for oath, before whom was proposed,
yes,
the commissioner for oath signed?
Yes, my lord. Yes, my lord, it was signed.
And the name there is Ike Additional Registrar 1.
Two, my lord.
Registrar,
yes, my lord.
Registrar 2.
Yes, my lord.
So who is Ike Additional, Divisional Registrar?
It's Cynthia, my lord.
Can you hear me?
Yes, my lord.
So, and that's the commission that you have there.
Yes, my lord.
My lord, the motion on notice dated 1st day of April 2022 is incompetent.
In what way?
Because what we have before us, it wasn't deposed before a commissioner of oath, but before one, it was signed for the commissioner of oath.
What I have here, it was not signed for. Somebody signed and put Ike Additional Registrar 2. That's what I have on
what
record.
We have here on our own part, it was signed by EO litigation, something of that nature. Yes,
let me
EO
see.
litigation. That's what we have. So based on that, we're arguing that the process is incompetent and none of it.
Is the court, you are bound by the court record?
Yes, my lord, as the court pleases.
But actually, I can see something wrong here.
And even on that first day, my lord, the registrar was not in Lokoja. So I believe if your own process, my lord, is
which registrar was not in Lokoja?
That's the commissioner of oath. I'm sorry, the commissioner of oath that day was not in Lokoja. The day that
which of them? Wait, is it for whatever EO needs, or the EK additional?
The EK additional was not in Lokoja that day because we made attempts to file a process and we called him. He said he's not in town.
You know the EA additional?
My senior colleague in Lokoja knows him because that's when.
Not a him.
Well, EK additional registrar 2 is a female.
My lord, I don't know the person, but that's the name. And we made attempts that same day to file a process, but they informed us that the person is not in town.
Who informed you? You ought to have stated all that in the affidavit you filed. Who informed you?
We deposed that in our
clearly facts.
We deposed that in our. Let me see.
Facts in our affidavit must be clearly stated. Did you state facts leading to what you're saying that you went there? They said
in our counter, we stated that, my lord.
Paragraph what of your counter? When did you file the counter?
We filed it on the 20th. We tried filing on the 19th, but the Commissioner of Food was not around. We have to move down to Abuja to file on the 20th. That was why we filed on the 20th. But ordinarily, we could have filed on the 19th, and even in front of the notice of preliminary objection, the stamp that received it is at Lokoja and not even Abuja.
The stamp of what?
In front of the preliminary objection. The National Industrial Court stamp that received the documents was received in Lokoja, but we were unable to complete the service there because the commissioner was not there. We had to come down to Abuja.
Do you have any light to throw on that?
Conclude the process.
I received call from Lokoja that they are trying to fight.
Who called you?
The third judgment creditor.
Yes.
Mm-hmm.
That they cannot see an officer that will sign for them, and it has to be filed that day.
What date?
That was
19th.
Divisional registrar.
So,
are you online? You are there, Yakubu. They said the third claimant or judgment credit was in Lokoja on the 19th to file their, is it counter?
Preliminary objection, my lord.
File the preliminary objection, but there was no one in the office. Then another first and foremost, let me ask you, why is it that not counsel? I'm asking the divisional registrar. Why is it that in the process filed by the judgment debtors on the 1st of April, the commissioner for two different commissioners for both signed the process? Two different people. So what happened? Can you hear me? Unmute yourself. I can't hear you.
I think my lord can hear
now.
Yes, my lord. The reason why two people signed is to enable service to take place on that very day. That is why.
No, listen. A commissioner for oath who is signing an affidavit to be the one to sign all the copies. Not somebody signing one, another person signing another. What's the
I'm sorry, my lord.
The person that signed this person, who is
Is the court registrar that signs?
Who is he or it? So what happened to the other person? What happened to the EA additional?
EA additional wasn't around there.
When the first one was brought. So when the first one was, bring them separately. And divisional registrar. The affidavit that was signed by were they brought separately?
No, they were brought on the same day, my lord.
So why did somebody else sign one and another person sign another?
It means you are playing hanky-panky.
My lord, it's very obvious.
It means you are playing.
It's very obvious.
Hanky-panky.
But first and foremost, that would be an
my lord, it's in the interest of the court that we did that, my lord.
First and foremost, that would be an internal issue.
Oh my lord, this procedure is unknown to law.
Let's focus
the person who signed our own copy is not a commissioner of oath, and therefore it's against section 13 of the Oath Act 2004. As the law pleases.
But another the commissioner for oath signed one part, which is in the record. That's why I said I need to make that inquiry. The divisional registrar is on record now. The divisional
yes, my lord.
Internally, I will have to make that.
Because as I've said earlier, my lord.
All right. Now.
Yes, my lord.
Then counsel, Mr. Dangana. The first still remains that.
Yes, my lord. Yes, my lord.
So the issue of the fact that somebody signed one and the other person signed another will be taken up internally.
Yes, my lord.
Both have the stamp of the court.
Yes, my lord.
So let's go ahead as counsel to handle the application. Mr. Baido.
Lord, I take the hint of the court. I will be more careful, my lord, next time when we are filing to ensure that we will advise the court to do the right thing concerning the signature on the.
Move the application.
We are grateful,
my lord. Please, I want to be guided. I thought as if it's a preliminary objection that should be taken process.
Somebody signing this, somebody signing that. It's an internal issue caused by the chief registrar of the court.
Okay, my lord. Because
I'm going to make another that the chief registrar of the court investigates the report.
Because what we are conversing in that preliminary objection, my lord, is that the process is non and void. Because it is just as if it's not been served with anything. There's no, the affidavit there is incompetent.
Mr. Dangana.
Yes, my lord.
On record of this court, which is the document that the court will be of much concern to the court, says that EK additional, who is the registrar and the commissioner for oath, signed the oath before the court.
Rightly guided, my lord.
Only the one that you are presenting as somebody else.
Yes, my lord.
All I'm saying, we'll go by what is on the record of the court.
I'm rightly guided.
Go into the substance.
As the court pleases.
So, Mr. Baido, move your application.
We're grateful, my lord. My lord, on our part, before we move, we're going to do our best next time when we're filing to ensure that we cross-check signatures on documents. So we'll be proper before the court always. We're grateful, my lord. Lord, our application was filed on the 1st of April. We have a motion on notice. date 1st of April and filed on the same day, my lord. My lord, the applicant is brought pursuant to section 6 sub 6 of the Constitution of the Federal Republic of Nigeria as amended and under the inherent jurisdiction of this honorable court, my lord. My lord, the order application is praying for 2 orders. Another of this honorable court vacating the Ganeshi order absolute made on the 31st day of March 2022 against the judgment debtor's account with the 4th Ganeshi Bank on the ground of non-service of hearing notice on the judgment and on ground of fair hearing, my lord. And for such further
service of what?
My lord, on the ground of non-service.
On the ground of non-service of what?
Yes, my lord. Of the hearing notice. Yes, my lord.
On the judgment.
On the judgment debtors, my lord, and on the ground of fair hearing.
There is nothing like that here. What I have there here is that non-service of hearing notice.
Yes, my lord.
Judgment and fair hearing.
My lord, we're sorry. Non-service of the judgment of the hearing notice on the judgment debtor, my lord. The grounds for that states so, my lord. My lord, the grounds and the affidavit. My lord, the application is brought on the following grounds, my lord. On the as stated on the face of the motion paper. My lord, that at the proceedings of the 14th March 2022, by the consent of parties, the matter was adjourned for the 24th day of March 2022. That on the 23rd day of March 2022, at the office of the divisional registrar, local jail, we informed that the court will not sit and that a new date will be communicated to us. That is the very day, this very day, no hearing notice has been served on us, either by mail or by physical service. That it was only at the close of work on the 31st day of March 2022 that we got to know that the order 9 has been made absolute through the judgment debtor's account officer with the 4th Ganeshi Bank. That the order 9C was made absolute without service of hearing notice on the judgment debtor, thereby denying them fair hearing, the right to fair hearing, my lord. And that non-service of hearing notice on parties rob the courts of its jurisdiction to make such orders.
Mr. Baidu.
Yes, my lord.
Are you aware that there is an order 9C?
Are you aware that
there is another 9C made by this court attaching the
yes, my lord.
The money of the judgment debtor domiciled with the 4th judge,
yes,
Ganeshi.
We are very aware.
Yes, and you have appeared in this case.
We appeared, yes, my lord. We have been consistently appearing until we are without an.
We have been consistently appearing
before this honorable court to the last date, which was, my lord, on the 14th of March 2022, when
just a minute. Just a minute. You said except on...
Yes, my lord. On the 24th day of March, when the court did not sit, my lord.
You said you have been appearing.
Yes, my lord.
Except when? Except when?
Yes, my lord. Okay, no, my lord, we appeared till the 14th day of March.
Except when? You are not saying that except on a particular date when the order was made absolute.
Yes, my lord, except on the 31st day of March, when the order was made absolute, And on the 28th day of March, yes, no, 28th and 31st, there was a proceeding. We got to know there was a proceeding on the 28th day of March and on the 31st.
Mm-hmm.
Yes, my lord.
Very well. Mm-hmm.
My lord, the application supported by an affidavit, the post to by Olubumu Williams Obaido, myself. My lord, it's a 11-paragraph affidavit, and we rely on all the amendments herein. Well, this application is also supported with a written affidavit, in written address, sorry, my lord, in compliance with the rules of this court. We adopt same as our evidence in support of this motion. My lord, in reply to the counter affidavit filed by our learned friends to the judgment creditors, we filed a further and better affidavit on the 13th day of April 2022, my lord. My lord, the said further and better affidavit was deposed to by one Rukia Oiza Mohammed.
On 13th of April.
On 13th of April.
Yes, my lord.
Thirteenth of April.
It was deposed to Barikia Oiza Mohammed.
Okay.
Yes, my lord. My lord, it's a 4-paragraph affidavit. And we rely on all the position therein. My lord, in line with the rules of the court, we also filed a written address my lord, which we also adopt as an argument in support of our motion application. My lord, just to emphasize as a way of elaboration, my lord, we again refer my lord, to the case of Gwede versus Delta State House of Assembly and another, which, my lord, is the recent case on Ganishi proceeding. A Supreme Court judgment made 2019, where your learned brothers in the upper chambers, my lord, said that though a Ganishi proceeding may be commenced by an ex parte application at the stage of order 9, sir, my lord, that when the Ganishi proceeding proceeds into the stage of order absolute, it becomes a tripartite proceeding, my lord, which must be between the Ganishi Bank, the judgment debtor, and the judgment creditor, my lord. Yes, my lord, as it stands, that the recent and the
if I may ask you a question, what is the essence of you coming before the court, having knowledge of the Ganishi proceeding?
You appeared in this case.
You were served. You appeared
yes,
in this case. You were in this. except on the date that the order was made absolute. In what way has that prejudiced the case of the judgment debtor?
Milord, sorry to be clear, Milord, it was not just one day that we missed, that we were not informed, Milord.
But you were aware that there's an order night side. You appeared in court.
Yes, Milord. Yes, Milord.
Very well. So it means you are aware. You know the amount that they are claiming. So in what way has the order absolute prejudiced the case of the judgment debtor?
Milord, if I may refresh the mind of the court, Milord, at the 14th day of March, Milord instructed both parties to go back, calculate the judgment sum.
What are the both parties?
You mean, my lord, your order was directed to the judgment debtor and the judgment creditor, my lord.
To do what?
To go back and update on the judgment sum, having struck out the claim of the judgment sum.
It wasn't to both. The court gave the order directly to the judgment creditor.
No,
the record of court is clear. The order was directed at the judgment creditor to calculate the amount.
My lord, I do not know if the
not directed. It was not directed at both of you.
No, if I could remember very clearly.
I said the judgment creditor to calculate. Yeah, listen, I have it. This is the record of, and parties, including the court, are bound by the record of court. I said the judgment creditors are to calculate the judgment sum accrued to them, with the exception of the names of those struck out by the court, by filing a further and better affidavit. And I said they should serve same on the garnishee before the next adjourned date. No, and then the case was adjourned to the 31st of March.
Exactly, my lord. My lord, that's the proceeding of 28, which we're also not aware of, my lord. That's the proceeding of 28. That's what I've been trying to draw my lord's attention to.
Yeah, but you are saying, no, what you are saying is that the court ordered that both parties, the court wouldn't have asked the judgment creditor or debtor to go and calculate. The court ordered that the judgment creditor should go and take out the names of those that you brought an application stating that they don't want to be part of the garnishee proceeding.
As the court pleases, my lord.
And the court granted the application by striking out their names. So in order to have a clearer amount, I asked the judgment creditors to go and calculate. And they did. Further affidavit stating that this is the amount. So the question I asked, I will ask you again, has that in any way prejudiced the judgment debtor?
My lord, even the further affidavit that we're talking about was not,
that the amount they calculated is not in line with the judgment of this court.
We do not even have the idea of the amount they calculated because it was not served on us, which is against the procedure,
Judge counsel to the judgment creditor. You didn't serve the judgment debtor.
No, we were not served. He could not have proceeded. That's the case of Gwede versus Delta State, which is a more recent offense.
Speak to the court. Speak to the system.
My
because
lord,
counsel is in the
all
other
parties were duly served.
My lord, that's not true. That's not true, my lord. We're not served.
Well, let's check the record of court.
Yes, my lord.
Court registrar, come and check. When did they file the affidavit? The further affidavit. Then I counsel to the judgment creditor. When did you file the further affidavit? What date?
To be is dated 18th March 2022 and filed the same days, 18th March 2022.
I can't do that one. That was May 28th.
18th March. They filed on the 18th March. So where is the affidavit of service? I mean, proof. Which one is this? 97. Who filed this? In the 4th. This is not. This is different.
Milord, it could not have been a 18th March because according to what
that's Milord, what I'm saying. It's not. Because
it has to be after that. Milord.
Mr. Dangana, you should know when you file the further affidavit.
Sorry, my lord, the documents before me, that's the latest I have. My lord, it was filed on the 29th March 2022. And even the garnish were served with the process, because I even got the copy from him. All the parties were served, my lord. I'm very sure we did that, sir.
My lord, counsel cannot be sure because he has not told court that he personally served. He has not told the court that he personally served.
Mr. Baido, he doesn't have to personally serve. As long as the process is served, that is what the court is of concern. Not, I mean, should be of concern of the court, not whether or not counsel served. Court registrar, let me see whether or not the process was served on the judgment date. Mr. Baido.
Yes, my lord.
I'm asking you a question.
I'm asking you a question.
Sorry, my lord, I didn't get that, my lord.
Yes.
The question is, how has that prejudiced the judgment debtor? Is the judgment debtor saying that? Sorry?
We did not even have any information to guide our clients to check the judgment sum to be very sure.
Listen, what was the order NISA? What was the sum stated in the order NISA?
My lord, even the order NISA was not served on us. I just discovered that, my lord. That they've not been carrying us along.
Were you in court? Were you in court in reaction to the order NISA?
I was in court, my lord.
You didn't inform the court that you didn't have the off order.
Yes, my lord, I did not.
Very well. Yes, so it is taken that you had the order. And what did how much did the order NISA say?
My lord, to be frank, my lord, we did not have
the amount standing to the credit of the The amount was 32,945,550 naira 93 kobo, with a 10% interest thereon. And do you have the judgment there, Mr. Baido?
Yes, my lord.
Very well. What was the total sum awarded in favor of the judgment creditors?
Lord, the total of the sum was not, my lord, the judgment sum was not total on the judgment.
Eh?
My lord,
You said you have the judgment.
Yes, my lord. There are several figures.
So if you have the judgment, you should see the judgment sum there. Are you telling the court that the court did not pronounce any amount?
Yes, my lord. The court did, my lord. But there were several
The court
amounts.
did.
Yes,
so,
my lord.
So calculate it. Calculate it.
My lord, our position as advocates, as lawyers, it's our duty to be custodians of the law. It's our duty to not allow any party to trample on the principles of the law, which we all respect very well, my lord. My lord,
so what is that principle? Fair hearing.
Yes, my lord. If we allow the judgment, a party to go away, my lord, with non-service of other party to proceed into
Learned counsel. Learned counsel. You are now before the court. You file the process after I have made the order absolute.
Yes,
and ordinarily, I'm not supposed to even listen to you.
My lord, one of the grounds for which
listen, wait. I am not supposed to listen to you.
Yes, my lord.
Because I'm fontos official. I have already made the order absolute.
Yes, my lord. We'll take the hint of the court.
So whether or not it's just like delivering a judgment, I have delivered a judgment.
Yes, my lord.
So I'm not supposed to come back and be hearing anything. The judgment has to be complied with.
Yes, my lord.
But in the interest of justice, as you said.
Yes, my lord.
And in view of the auditorium pattern rule, I'm asking you this question. What was the judgment sum? Because the only issue that you have, that you have said, is that you weren't even sure of the amount. You were not told about the amount because you weren't here on the 31st when the order was made absolute in the sum of 32,786,165 naira 79 kobo. So you need to know the amount that the court had asked
your bank to release to the judgment creditors.
And I'm asking you a question. What was the judgment sum?
My lord, let me get a calculator and attempt to calculate, my lord.
Okay. You were served with the judgment, right?
Yes, my lord.
Very well.
I'm trying to calculate, my lord. My lord, it seems my lord did not get our argument at all, my lord.
I got your argument.
My lord, our argument.
I got it right. Your argument was that you didn't know. You were not in court on that date.
Yes. My lord, we are arguing that the court cannot even make the judgment, the order 90 absolute, without the three parties present, my lord. By the authority
I am telling you that the court actually ordered that they should serve whatever processes on the on the garnishee.
Yes, my lord.
That is the further affidavit that you said you were not served. I didn't ask that they should serve it on you. The order of court on record was that it should be served on the garnishee because they have to release the money. And you said, but you weren't informed of the date of the 31st.
Yes.
And so you didn't know. And I'm asking you, in what way would you have been, were you prejudiced? And you said you didn't even have the amount. And I'm telling you, okay, calculate the amount, because you have a right to know the amount of money that is coming out of your account. And I'm asking you here, calculate the amount.
Lord,
and let's see if the amount is more than what you were supposed to pay.
My Lord, we are trying to calculate, my Lord.
Go ahead.
Yes, my Lord. Well, if my Lord will allow me to clarify myself as my colleague is calculating, my Lord. Lord, our argument is that.
Look, your argument is that you ought to be you ought to be told. Yes, now you know. Now you are before the court. Mr. Obaido, now you are before the court. Go ahead and calculate the amount and let me know.
It's about 30 million, my Lord.
The total amount?
Yes, my Lord. About 30 million.
Don't tell me about. Don't tell me about. Give me the specific amount.
30,916,000, my Lord.
Council should not be funded. So
30,916,208, my Lord.
Very well.
Yes, my Lord.
30 million.
Yes, my Lord. 916,208. Yes, my Lord. Removing that, my Lord, that's with the exception of the 11th to 22nd claimants, my Lord.
Oh, you have removed the 13th to the 22nd claimant.
Yes, my Lord.
Okay, so that is the balance. That is the actual amount that should go to the first.
Sorry, my Lord. Sorry, my Lord. It seems my colleague was making an error. Let me clarify. My Lord, if I may be guided, that's our calculation. This one's was started. 11 to 22nd, their name was subtracted. So their claim, just this one, the claim was subtracted. This one, then this other one.
Are you through? Are you through?
Yes, my Lord.
So the total is how much?
Okay, my Lord, sorry. 30622,583. 30622,583.
Okay.
So
when the court deliver the first and foremost, judgment creditor, or for all of the judgment creditors, the calculation you made?
My Lord, for the judgment creditors, with the exception of the ones that their names have been struck out, my Lord.
Very well. So you got 30 million. Come again, 30 million.
622,583.
622,583 what?
583, my Lord.
83 naira. Any kobo?
No, my Lord.
Okay. So 10% interest from when was the date of the judgment?
My Lord, the judgment was on the.
The judgment was delivered on the 26th of March.
Yes, my Lord.
And the judgment debtor were given 30 days within which to comply. And so 30 days plus 26, that's 46 days. Let's say
will start counting from there.
2021 till 31st of March. How many months is that?
No, sorry, my lord. I'm lost, my lord.
What registrar?
Lord, we're lost.
I asked a question. I said 10% interest on the judgment sum. You have said that with the exception of the judgment creditors whose names were struck out of the garnishee proceeding, the total amount due to the first to the 12th garnishees is 30,622,583 naira. So I'm now asking you, what is the percent interest on this sum?
Lord, sorry if I may be honest.
Because the court awarded 10%
One of the reasons why I chose to be a lawyer because I was not very good in mathematics, my lord. If I could be very honest with the court.
Very well.
This is something I would have loved.
Court registrar. Senate counsel. We asked the court, the auditor of the court, the accountant department of the court to make the calculation.
Except that, my lord, because I am not very competent with mathematics.
They did. And after doing, we added it together with the total sum. And it came up to be 32,786,165 naira 79 kobo, including the cost of the garnishee proceeding, which is 250,000 naira awarded as cost. So that was the judgment, I mean, the other absolute aid. So that is that. You note the amount. Mr. Dagana.
Yes, my lord.
Let me listen.
My lord, we have the counter.
When was it filed?
It was filed on the 11th day of April, 2022.
The
19 paragraph affidavit deposed to by Honorable Obaje Johnson, the third claimant's judgment creditor, respondents in this suit. And we are relying on all the abatements. We are relying on all the abatements.
Abatement.
In the counter affidavit. And also adopt our written address as our oral submission. And urge the court to dismiss the application of the applicants because it is tantamount to asking the court to sit on appeal on its own judgment, on its own order. Which is trained in our legal system.
Very well.
That's our humble prayers. We also pray, that the court should make an order that the judgment sum should be paid within 24 hours by the 4th
Yeah, you want to give the court direction.
Scott, please.
You think it's within your power to do that?
Oh my Lord.
To urge the court to make an order within so hours.
I'm sorry, my Lord. I withdraw that.
Better do.
Thank you.
Please, when you're done, let me send it to me. I'll go and buy the price.
Mute yourself. Mute yourself.
I think it's the letter of adoption and the final return.
Court registrar, divisional registrar, mute yourself. When did you say you filed that the further affidavit stating the amount after deducting the 13th to the 22nd judgment creditor's name? Because actually the amount standing to their credit, Mr. Baido has also deducted it and said it's 30 million. So what day did you file that process? I just need the date, that's all. Okay.
29th March 2022.
Okay. Here is the ruling of the court. I've heard learned counsel, both learned counsel for and against the application seeking to vacate the order absolute made by the court on the 31st of March 2022, urging the Fourth Ganishi to the Fourth Ganishi Access Bank to pay the judgment sum of 32,786,165 naira 79 kobo to the judgment creditors. It is on record of this court that the judgment creditor applicant filed a Ganishi order the Ganishi proceeding ex parte on 16th of July 2021. The order was granted on the 18th of October 2021, and it was the second Ganishi then was ordered to pay the only sum they revealed was available to the credit of the judgment debtors, which was complied with. They came back, and then on the 16th of November 2020, application for stay of execution, the court took it and it was struck out. On the 8th of December 2021, the judgment debtors and the judgment creditors filed a motion and a notice of about both applications. On the 17th of January 2022, the judgment debtor and judgment creditors, as well as the Access Bank, the counsel to the Fourth Ganishi, were all in court. And then a counsel for the judgment debtor, Obaido Esquire, was in court, and the court directed the Fourth Ganishi to file an affidavit to show cause, which was not filed before then. On the 14th of March 2022, the Judgment Debtors Council, Obaido Esquire, was also in court, and as the Judgment Creditors Council, as well as the Judgment Creditors Council and the Ganishi Council, who again failed to file the appropriate processes before this court. Bami Boshe Esquire was again directed to file the FourthGanishi's appropriate affidavit to show cause. And on the, yes, which was complied with and filed by the Fourth Ganishi on the 14th of March 2022. Before then, the judgment debtors and the 13th to have their names struck out of the proceeding, leaving behind the 1st to the 12th judgment creditors. The court had the application and granted their prayers. It is in view of this that I directed the judgment creditors to deduct the amount due to the 13th to 22nd judgment creditors from the total amount claimed in the Ganishi proceeding. They did and filed the process on the 29th of March 2022. The court on the 31st of March 2022 then considered the amount accruable to the first to 12th Ganishis, vis-a-vis the judgment of the court seeking to be enforced, which was delivered on 26th of March 2021 and arrived at the total sum of 30,622,584 naira. The amount also admitted by Learned Judgment Debtors Council as the total judgment sum accruable to the 1st to 12th Ganishis. The court then directed the account office to calculate the 10% interest and the 250,000 naira cost of the Ganishi proceeding, and the total amount accruable to the 1st to the 12th Ganishi is a total sum of 32,786,165 naira 79 kobo, after deducting the deduction of the earlier 1,848,365 naira 59 kobo that was paid by Zenith Bank to the judgment creditors. It is now obvious that the judgment debtors are not in any way prejudiced by the order absolute made by the court on the 31st of March 2020, above stated to the judgment creditors. Assuming, but I do not concede to the fact that the judgment debtors were not served with the hearing notice of the sitting of the 31st March 2022, or put in another way, that they were not given fair hearing. First, the court registrar had earlier informed the court, and I believe to inform him of the date. Phone calls are now settled as means of communication to parties by court. Learned Judgment Debtors Counsel, W. Obaido, Esquire's grounds is not that he has not been appearing in this court in respect of the Ganishi proceeding, but that he was not aware of the 31st of March 2022, the date the order was made absolute. That the court registrar had discountenance and that controverted either that the Judgment Debtors Counsel was informed, that suffices in the calm view of this court as notice. Flowing from all stated supra, coupled with the fact of the case as evinced on record, I find that the judgment debtors have been given adequate and sufficient notices and have participated fully in these proceedings since the date of hearing of this Ganishi proceedings. Consequent upon which I find this application to be meritorious and an attempt or ploy to stall the cause of justice. Accordingly, the motion on notice filed by the judgment debtors on the 1st of April 2022, after the court has made the order of Ganishi absolute in this case, is dismissed. The order absolute made by this court on the 31st of March 2022, urging the fourth Ganishi Access Bank to release the sum of 32,786,165 naira 79 kobo stands. The fourth Ganishi is to release the said sum to the third judgment creditor, Honorable Obaja Johnson, within 24 hours from now.
My Lord, we are most grateful.
Any other matter?
My Lord, we are.
Any other?
My Lord, we are equally very grateful. Want to appreciate the God for the industry put into that building. And we also want to say, my Lord, that we are always learning from your judgment whenever we are in your court. We are very, very grateful, my Lord.
Very well.
Thank you.
Mr. Obeido, if you must know, the court took it upon itself to do all the calculations. I never left it for the judgment creditors to do.
Lord, we are grateful.
In order to ensure that none of the parties is shortchanged, I ensure that the court was involved in making the calculation. And you had even confirmed it by the calculation you made with regards to the first to the 12th judgment creditors, which was the same amount. And the court ordered its auditors, I mean, its accounts department should calculate. I don't leave that, the interest, I don't leave that to judgment creditors to calculate. I always ensure that it is the court staff, the court account department that calculate the interest rate, because they can go and calculate anything. I won't take that because the court that actually awarded the interest. So the court ensures that the proper thing is being done with regards to the interest.
My Lord, sincerely, we are very grateful.
So is that all for the
put into it? We are very grateful, my Lord. Thank you.
Very well.
Yes, ma'am.
Thank you. Very well.
Get some clarity regarding the order. So is it 24 hours from receipt of from now, from today? That's yes, yes. Yeah. Yeah.
Yeah, come on.
Understood. Yeah. Progress for my lord.
You for the call. No call. Yeah.
No, it's not that. I was thinking maybe a copy of this movie because you know the bank will want to use. So you told me this is what your lordship directed. You need to tell her from the. That's what I was asking her. But since she's made it clear that it's from total.
Trying to hear that behind the scenes.